Well, I'm back. I can't believe I'm doing this, but I just couldn't get this case off my mind. And so I want to look at some of the initial legal posture in some of the parts of the case. And so I thought I'd look and see how Missouri looks at a few things, particularly how they look at defamation and whether there's even a legal case of defamation. And I wanted to look at some of the jurisdictional issues as well. So follow along. I may break this up into two parts. I don't know how long it's going to go. We'll see how it goes. I'll try to do it in one, but no promises. So the court could look at it and decide as a matter of law that the words spoken by the defendants are not even worthy to get to a jury. That's one of the things we're going to look at. We'll get to it later. I looked at a few cases, so you're basically going to hear me thinking out loud. And my script is basically a couple of cases that I looked at to get a feel for the posture of the court. Yeah, my coffee's cold. So it is a growing area of the law, particularly defamation on the internet. The internet's a big thing. I can remember being on a forum a few years ago, and I was appalled at some of the things that people were saying. In fact, a few friends who were on there, I messaged them privately and said, hey, you better delete what you just said, because you clearly crossed the line in terms of defamation. You have to be careful what you say on the internet. You can be held liable, particularly if you're saying things about somebody that's going to hurt their business, going to cost them money. They're going to lose in their reputation. Be careful what you say. There are ways to say things that convey your opinion about a matter without getting sued. And I'll cover a little bit of that here in this video. So probably it helps some of you that are outside the U.S. to understand how the legal system works and the Constitution and the federal district courts and so forth, all of that. So I'm going to insert here a little snippet that basically explains the United States court system in a broad nutshell. It's not going to go into a lot of detail, but it might be helpful to some of you. So take a look, and then we'll get back to the analysis of some of these court cases in Missouri. So let's go over the laws in America and the court system in particular. At the very top, you've got the U.S. Constitution. This is a document that we brought into existence in the beginning of our nation's history. All laws in America must meet the constitutional standards set in that document. Now, courts are established to interpret the law. In our federal system, we basically have three categories, although there are many other cases, or rather courts, such as the Admiralty Court, Tax Court, a lot of specialized courts. But for basic purposes, we're going to talk about three courts. You got the Supreme Court, and it only takes cases it agrees to hear and cases between two states. Then you've got the appellate courts. There's 13 of them. They hear all cases appealed by a litigant in the district court. Then you've got district courts. There's 94 of those spread around America. This is where a case starts in the federal system. After that, you've got the state court system. Similar to the federal system, they have a Supreme Court. And again, they only take cases appealed from the appellate court. Then, of course, you've got the appellate court, which they hear all the cases appealed by a litigant from the lower courts, which are county level courts. Now, every state has different models. Some have circuit courts at the top level in the county. They call them different things, superior courts. Then there's divisions within there. So there'll be criminal courts as well as civil courts. All civil cases will begin here. All civil state cases, including cases not valued over a certain dollar figure, which go into a small claims court. Now, a case that's based on a state's laws, such as defamation, a state has a defamation law, they may be filed in a federal district court if certain conditions exist. And that's what Hans is alleging. He's got a tort case, which is a defamation case, and he's saying that Missouri has jurisdiction and that he could file this in federal court because there are other things that are applicable here. I think there's a federal law issue that he's injected in his complaint. And there's certain things that are set up in the system or in the court rules where if you have it's diversity, if you have diverse citizens in different states or locations, and there's a certain amount that it's over, then you can put it in the federal court system. So that's what's happened here. Remains to be seen whether the federal district court in Missouri will accept jurisdiction. I'm sure there's going to be a battle on that. So we'll continue the discussion on the case. I just wanted to give you a little overview. So we're back on the record. The courts are split on a number of issues dealing with jurisdiction, defamation, and the internet. It's a growing body of law, and it's going to keep growing, trust me. There's a case that I looked at to give you a kind of an idea. It's Baldwin versus Fisher-Smith. And I'll put a link to the case for those that are interested if you want to read the case. Kind of an interesting case. It's a Missouri case. It deals with jurisdiction and defamation in the internet. So the plaintiffs, these are the people that sue. The plaintiffs are the ones who feel they've been wronged. So the plaintiffs in this case had a business called Whispering Lane. And they basically did a show and sell for Chinese cresteds, I think it was, dogs. And they were in competition with the defendants. Now, the defendants lived in Arizona and Pennsylvania. And they bought a website. The defendants bought a website. And they called it StopWhisperingLand.com. And they used the website to malign the plaintiffs, to basically to defame them. So there was a jurisdictional issue. In 1 year, the website got 2,500 hits, of which 25 were by Missouri residents involved in the dog business as owners, breeders, or exhibitors. So the plaintiff, Whispering Lane, sued the defendants for libel and other matters, tort theories. The defendants immediately, by the way, they sued them in Missouri. The plaintiffs or the defendants moved to dismiss because of a lack of personal jurisdiction. So there was and this is typical and common, there was a amended complaint made and they repled, and the defendants again sought dismissal. The trial court granted and dismissed the case. And they based it on the plaintiffs not having met what they call the minimum contacts test. So the defendants have to have, and this is true in virtually any state, must have minimal contacts for jurisdiction to to exist under the state's, what they call a long-arm statute. This is what every state calls their statutes. A long-arm statute. It says this is the law that allows a state to reach out and pull a defendant in to its jurisdiction, to its state. So the case was appealed. It goes up on appeal. And the appellate court made an interesting ruling, and it'll give you an idea of how they're going to look at jurisdiction in this case. And one of the cases that the Missouri court looked at was a rather famous Supreme Court case involving actress Shirley Jones and the National Enquirer. And I'll put a link to that in case any of you are interested. It's called Calder versus Jones. And it was a 1984 case. And anyway, basically, the defendants, you know, if you're familiar with the National Enquirer, you know, they've got all this juicy gossip about everybody. And so apparently they wrote some stuff that Shirley Jones didn't like. Now, she lives in California. They live in Florida. The defendants have their business in Florida. She filed the lawsuit in California, and the defendants immediately, of course, moved to dismiss based on jurisdiction. And believe it or not, this case ran all the way up the ladder to the Supreme Court. Amazing journey. Supreme Court found that the defendants, and I'm going to quote here, were, quote, primary participants in an alleged wrongdoing intentionally directed at a California resident, and jurisdiction over them is proper on that basis. So these defendants were in a action that was intentionally directed at a California resident. So the intentional targeting and tortious activity towards a foreign state is known as the effects test, EFFECTS, the effects test, for establishing specific jurisdiction. Now, the Seventh Circuit, which is part of my jurisdiction and also Missouri, has held that, quote, Calder suggests three requirements for personal jurisdiction in this context. One, intentional tortious conduct. Tortious conduct means wrong, bad. You know, a tort is a claim for something you do to me that's wrong. So it's called tortious conduct. And two, that it's expressly aimed at the forum state. And three, with the defendant's knowledge that the effects would be felt. In other words, that the plaintiff would be injured. So in Missouri, the standard for defamation is as follows. One, there must be a publication. And publication means oral, which is slanderous, or written, however. So it must be a publication of a defamatory statement. Three, that identifies the plaintiff and that is false, that's published with the requisite degree of fault, that has a whole lot of room for debate as to exactly what that means. And the court really has narrowed all that down and outlined what that means. And finally, six, damages the plaintiff's reputation. So you've got to have proof of actual harm. You can't speculate on the damages. And by the way, in an earlier video, I mentioned something about per se and per quad defamation. Missouri has since done away with the distinction between the per se and the per quad. You've got to prove your damages per se or per quad, doesn't matter. So you got to have proof of actual harm. You can't speculate. And it must be founded on, quote, and this is from the Missouri case, more than the plaintiff's embarrassment or perception of their own reputation. So they're quoting this favorably. And then Missouri court quotes Prosser in the Law of Tort. Prosser's this very famous professor, guy on law, and he wrote a book on torts that's followed by every law school. Every law student is familiar with this book. and it's held in high regard in every state. So, quote, defamation is not concerned with the plaintiff's own humiliation, end quote. Now, court's quoting that. So the Missouri moved on and they stated that in this case that they, like an Illinois case that was heard by the Seventh Circuit, and it's called Tamburo, T-A-M-B-U-R-O, and they quote the Seventh Circuit. In the Seventh Circuit, by the way, is an appellate court, and it's called the Seventh Circuit. It covers Chicago and Illinois, Indiana, Missouri, a couple other places. Anyway, it's called Tamburo. They said, quote, the individual defendants purposely targeted Tamburo and his business in Illinois with the express goal of inflicting commercial and reputational harm on him there, even though their alleged defamatory and otherwise tortuous statements were circulated more diffusely across the internet. Tortuous acts aimed at a target in the forum state and undertaken for the express purpose of causing injury there are sufficient to satisfy Calder's express aiming requirement. Remember, Calder is the Shirley Jones case that was dealing with jurisdiction. So the Seventh Circuit went on to say this: under even the most rigorous approach to the determination of whether the plaintiff's injury arises out of the defendant's contacts with the forum state, Tamburo's injury, Tamburo, by the way, was the plaintiff, clearly does. We've already concluded that the defendants expressly aimed their allegedly tortuous conduct at Tamburo and his Illinois-based business for the purpose of causing him injury there. These contacts within the forum state are the cause in fact and the legal cause of Tamburo's injury. That is, Tamburo's claims arise directly out of the individual defendant's contacts with Illinois. So basically the court is saying, hey, you know what? He reached out, the defendants reached out to cause harm to the plaintiff, and they aimed at him where he's located in Illinois, and therefore jurisdiction is there in Illinois. And the Missouri court, of course, is quoting Seventh Circuit. And the Missouri court concludes, quote, there's no meaningful difference between Tamburo and this case, and the same result follows here. Defendants' contacts were constitutionally sufficient for the trial court to exercise personal jurisdiction over them. And we're talking about the dog case. So this is where the people had this dog showing, and they raised these different dogs, and these two defendants from Arizona and Pennsylvania bought this website and basically maligned them. And so the Missouri court is saying, you know what, they reached out here and they aimed at the defendants here in Missouri to hurt them. And that court, just like this court, defendants' contacts were constitutionally sufficient for the trial court to exercise personal jurisdiction over them. So the court also said, quote, third, we are not overwhelmed by the occasionally expressed concern about internet activities exposing a defendant to jurisdiction in many forums. A tortfeasor who mails 1,000 bombs to recipients in one state and one to recipients in each of the other 49 states should not be relieved from geographic responsibility for the consequences of his actions in each of those states simply because he is subject to suit everywhere, or because his conduct has a uniquely intensive relationship with a single state. So they're saying basically, jurisdiction is basically everywhere. And, you can't say, well, jurisdiction's better over here or better over there. If jurisdiction exists, it exists, whether it exists, in all states or whether it exists just in one state is irrelevant to the court. So the Missouri is going to look at each defendant and do an analysis based on their ruling in this case. And for example, with Nakamura, they're going to look and they're going to ask, were his words, get this, intentionally tortuous conduct? They're going to ask that question. They're going to reason within themselves. They're going to make this. They're not going to ask Nakamura this. They're not going to ask his attorney this. They're going to look at the documents and they're going to say, do we think this was intentional tortuous conduct? They've got to make some preliminary, and we'll get more into it, determinations about the words themselves as to whether they're going to bounce it on all the way to the jury or they're going to dismiss. Number two, were they expressly aimed at Missouri? We'll get into it a little bit, but it's going to be a little bit problematic, I think. Number three, did Nakamura utter those words with the knowledge the effects would be felt, i.e. that Hans Niemann would be injured? That's definitely an issue. It's not a problem that Nakamura is not a resident of Missouri. It would help, or I say Nakamura and Niemann, it would help if he was just a visitor. But there is a problem in that his residency is in another state. I think he lives in Connecticut, if I recall. So then the question for the court becomes, were the words aimed specifically at Niemann, or Niemann, however you pronounce it, in Missouri? So there is an issue that arises from this. Missouri appears to be kind of peripheral in all of this. And it's going to be interesting as to how the court treats this aspect, i.e. the targeting in Missouri. Is it possible, is the question, to find that Nakamura believed it would harm Niemann in Missouri? Is it possible? I don't know. Don't know the answer. Niemann just happened to be in Missouri playing chess. And does this render void Nakamura's or Carlsen's fair reportage privilege that Missouri allows? Was he just reporting on an issue in the chess world? That's a good question. That definitely is going to be an issue. And what about the rather generous treatment that Missouri gives, called the opinion rule? So in Missouri, there's an interesting case, and we're going to get into that case as well. In Missouri, the court must decide whether a statement that's alleged to be defamatory is capable of having a defamatory meaning. So you got to make that decision. Not as a necessarily, they're not taking the place of the jury. They're just saying, is this capable, these words capable of having a defamatory meaning? So they also have to determine whether the statement is one of opinion or fact. And the determination of whether the statement is defamatory or a statement of fact is left to the jury. So in the case called PAP, P-A-P-E, versus Reither, R-E-I-T-H-E-R, the court held that statements of opinion are protected by an absolute privilege rooted in the First Amendment. Now, there is an exception that the Missouri court made to the rule. And the exception is that the privilege does not apply when the statement of opinion necessarily implies the existence of undisclosed defamatory facts. Don't ask me what that means. I'm not real sure. I would have had to spend a few hours exploring exactly what the court had in mind with those words. I could guess, but I don't want to guess here. Suffice it to say, in PAP, the court held the phrase, this is very important to this case, keep this in mind, the PAP court held the phrase, quote, "it is my position," end quote, should be construed the same as, end quote, "it is my belief," close quote, which clearly indicates an opinion. And you'll see a little bit later on in this video why that is so important in this case. So the court's also going to consider what's called the totality of circumstances. In other words, what were the circumstances under which the words were uttered? That can be very important. For example, I'll give you just a hypothetical example. So driver one, who happens to be a famous race car driver, he turns in front of driver two as they happen to be driving on the same highway at the same time. So driver two later describes the event to several people, and he names driver one. And in a loud, angry voice, he says, "He's a lousy driver. He shouldn't be allowed to drive a kiddie car, let alone a race car. I wouldn't let him drive me to the hospital." Missouri court will look at this statement and, consistent with their standards, would likely consider all the circumstances and call it an opinion uttered in an emotional state, not uttered as fact. So the court will, in this case, ask whether the defendants in the Niemann case made an apparent factual statement in which vituperation and hyperbole, which I just gave you an example of, are expected so as to make it an opinion. Otherwise, it's probably defamatory. So what the court will find in this case remains to be seen. But let me read kind of what was said in the PAP case. Generally, this is the court I'm quoting from in the PAP case, any statement preceded by a phrase such as, open quote, "it is my position," or, quote, "it is my belief," and other cautionary phrases are as a matter of law. In other words, it's written in stone. It's black and white law. As a matter of law, opinion. Did you get that? Any statement preceded, in other words, in front of, such as, "it is my position," or "it is my belief," or other cautionary phrases, are, as a matter of law, opinion. And then the court goes on and says this, quoting PAP again, "Put plainly, it is impossible to interpret statements preceded by such cautionary language as positing a verifiable proposition, and verifiability is the crux of the fact/opinion distinction in defamation law," close quote. That is so important in this case, believe me, especially to Carlsen. The PAP court also held that, quote, "a statement must be verifiable at the time it is issued in order to be one of fact." That could play out to be very important too. So Carlsen's statement uttered on September 26, 2022, which I think is what landed him in hot water with Niemann, was this. He said it on September 26th, quote, and I'm quoting Carlsen now, "I believe that Niemann has cheated more, and more recently, than he has publicly admitted." The Sanquefield Cup, I don't know how to pronounce it, ended on September 12th. This statement was made on September 26th. don't know how, Hans, you're going to find jurisdiction on that statement in Missouri. I don't know. Maybe they'll link, I mean, you got to link that statement and others back to his first action of just walking out. Now, I know he's alleged to have said something to the officials. I don't know what he said. I know what Hans alleged that he said. Whether he said that or not, I don't know. Was Hans in the meeting when he said it? How did Hans know what was said? So, we can only speculate there. But, maybe Carlsen said something to them when he walked out. Maybe he didn't. I really don't know. But if he's based it, and it looks like in his complaint, if he based it on the September 26th statement, he's out of luck. That the Missouri court's going to hold, and that's the only place I know where he flat out came out and said that he cheated. The court's going to hold, the Missouri court's going to hold. That's an opinion. You can't sue on the basis of an opinion. So was Nakamura expressing an opinion when he did his podcast? I don't know. I haven't heard all his broadcasts. I think I've heard one or two. I remember on one, I don't remember which one. I remember wincing at one point. But I also remember that whatever he said wasn't libelous. I just felt uncomfortable. I've got a lawyer's mind, and I think, I'm thinking like if this is a client, I'd be calling my client up and saying, hey, you ought to back that off a little bit. Don't get so close to the line. So that's kind of how I was thinking at that time. So the case here, I think in part is going to depend on the timing of the broadcast for Nakamura. When did he say whatever he said that is supposed to be libelous? If he said it after the tournament, I don't think there's jurisdiction. If he said it while the tournament was still there and game was still going, jurisdiction might attach. Realize this. The mere fact that the court finds jurisdiction, and it may find jurisdiction, doesn't mean the case will not ultimately be tossed out. Jurisdiction has nothing to do with the merit of the case, okay? So the PAP court went on to say, I'm still quoting from this PAP case, fourth, our Missouri Supreme Court recently expressed a broad jurisdictional view of communication that gives rise to intentional tort claims. That court said, where the actual content of communications with a forum gives rise to intentional tort causes of action, as Mr. Bryant's petition alleges here, this alone constitutes purposeful availment. And so the court used that to conclude this. They said, fifth, to tweak an observation from the case Revel v. Lidov, if you pick a fight in Missouri, you can reasonably expect to settle it here. They were being tongue-in-cheek here, but they're basically saying, if you do something bad in Missouri, we're going to find jurisdiction. So, as I said from the get-go of this, jurisdiction's still a huge issue. All the parties I expect will resist jurisdiction. Frankly, I still can't wrap my head around the chosen venue here, but it is what it is. Maybe the lawyers, Niemann's lawyers, I'm sure they know more than any of us know about it. And they had to see something as to jurisdiction attaching in Missouri. I'm assuming they're not all buffoons. I'm assuming that they kind of know what they're doing. You don't take cases like this unless you know what you're doing. Well, let me rephrase that. If you're smart, you don't take cases like that. I have to qualify it because the first case I took out of law school, hadn't even done a small claims case, was a federal district court case. It was a discrimination case against one of the largest corporations in the state. And that was my first case. So, you know, sometimes, and I didn't know what I was doing. I won the case, but by the grace of God. But generally speaking, you don't take cases where you don't know what you're doing. So I'm assuming his lawyers know something that, you know, says, hey, jurisdiction, I think we can hang jurisdiction on him here in Missouri. So we'll see. Nakamura, don't know where you stand, man. Don't know what you said and when you said it. Even if you said defamatory words, I'm not saying you did, even if you said them, doesn't mean that jurisdiction is in Missouri. Maybe Connecticut. So jury's going to have to make that decision ultimately, or maybe the court will throw it out, find that, you know, it was just opinion. They could dismiss it. And again, caution you, just because a court, you know, finds there's jurisdiction doesn't mean that he's decided the merits of the case or she's decided. So we'll see. I've not looked at chess.com or the president, who's also named. I've not really looked at their case. I haven't looked at the Sherman Act liability potential there because, frankly, it's way too deep for me. I'm not going to spend 8-10 hours wading through all that stuff. I don't think so, not unless I get real curious. So, we'll see what happens and when. I think there's going to be a serious issue, though, where to sue Carlsen for sure. I'd hate to be a plaintiff's lawyer here. There's so many legal landmines, and somebody in those law firms or that law firm, they're going to be writing legal briefs day and night in anticipation and in response to a myriad of issues that are going to spring out of this litigation. Trust me, it's going to happen. So, all right, I'm going to try and get back to my original intent of this channel, which is legal war stories, which I originally decided to do for my kids and grandkids so they could hear some of Grandpa and Dad's experiences in the law, which most of them have never heard. And I'm going to try and get back to that. But if things really get out of hand on this Niemann Carlsen thing, I may dive into it again. We'll see. So I've put a few links in the description of things that might interest you. Y'all have a good day, and we'll catch you again. Bye.